My name is Alicia Porcena, and I am the Program Manager for National Programs here at Enterprise. Enterprise is the national curriculum provider for emerging leaders, and we hire instructors in local communities to provide the curriculum. Today we have Suzi Lemen as an instructor from Jacksonville, Florida. Suzi is going to talk about HR legal pitfalls, the law, and how to keep from writing big checks. And Suzi, I'll let you take it from here.
Welcome, everyone. I'm glad you're on here. We're down here in Irma recovery mode, and luckily we didn't miss too much in terms of power, and we had a few roof problems with our employees, but all is good. And it's been interesting time and lots of HR issues that come up with storms. So today we're going to talk about some really critical things that you need to be aware of as business owners. And I'm trying to figure out how to get this thing to move forward. Let's see here. Okay, there we go. And we're going to talk about the law, but some of these things are also best practices that will help your productivity and your profitability. So let's jump right in. I want to encourage you to type questions as I'm talking, much like as if we were in a classroom, and I will catch those and answer them as we go along. And if I can't get to all your questions, you can always call me after the webinar, and I'll be happy to help you. So let's jump right in. I always start with the news, and we always update this slide. So this is hot off the press, and really, HR is in the news all the time, and you may not be as hypersensitive to it as I am, but these are things you need to be concerned as a business owner. Maybe you own franchises. So Kentucky Fried Chicken is a franchise, and one of the franchise owners was recently sued for disability discrimination, and the case is basically where one of the employees was taking medication that was prescribed by her doctor for a bipolar disorder. The restaurant owner thought that she shouldn't be taking the medicine, which is kind of interesting, referred to him in obscene terms, and made her destroy the medicine at work by flushing it down the toilet. And when she told the owner she was going to continue to take the medication because her doctor ordered it, he basically fired her. Now, you can argue that that sounds pretty stupid. And of course, these are only the facts that were released by the EOC. But, this is going to be a big check. It's not smart. I guess the question is, do you know what your supervisors are doing? So if you have a business with other supervisors, do you know what they're doing? Because it might have been, hey, I don't believe in that kind of medicine. I think you should throw it away, that kind of thing. And of course, now the owner of this business and probably Kentucky Fried Chicken, the franchise, are in big trouble. This Stemlet Growers is an organic tree fruit company out of Seattle. This was a tractor driver, worked for the company for over 3 years, and then went to a different location where she was the only female. And a direct supervisor drove her to a remote area and made sexually explicit comments to her and propositioned her and attempted to kiss her. And she complained, and then he basically made her pick up trash, which is another offense, right? And excluded her from meetings with other drivers, and she reported to her harassment to upper management, and the way that they dealt with it was they wanted her to transfer to a job that paid less and lower her pay, and of course she's suing. So here is another case where management not only didn't take it seriously when they found out about it, but weren't managing their supervisor properly, and that's going to be another big check. Here's a bank. You think banks kind of know what they're doing, but in this case, this Heritage Bank, which is in a little town in Wood River, Nebraska, Heritage Bank, it was a woman that sold insurance as a relationship manager for the bank, And there was another woman there, and they paid the women the same, and then they replaced one of those women with a man and paid him 33% more, which of course is in violation of the Equal Pay Act. And then we have a restaurant chain, the Rosebud in Chicago that owns, there's 13 Italian restaurants. I don't know if anybody from Chicago is on the call, but the managers, including the owner of the restaurant chain, was using racial slurs to refer to blacks and refused to hire African Americans because of their race. And a few other things the EEOC found, which are lessons to learn, is they failed to maintain employment applications for a year. They failed to file employer information reports. And so this is a huge case, and they lost and had to pay out $1.9 million. So that's a lot of spaghetti dinners. So these things are in the news all the time. And so the goal in HR is to help you to mitigate that risk and lower the risk and hopefully eliminate as much of it as we possibly can. And at the same time, to make sure you have employees that are doing what you need them to do so you can make some money, right? Because we're all in business for that. So just why is HR important? And I feel a need, and I have this in every presentation, you know, HR problems are stressful. So if you do HR well, you can lower that stress and have happier employees and less risk of lawsuit. But less obvious is that empowerment. You know, people feel, if they feel good about working, they're going to work better for you, work harder for you, and help make you more money and better focused and positioning you for growth. And of course, this program that we're all involved in, Emerging Leaders, is all about growing your business. So we're going to jump into, as much as we can, some of the laws that affect pretty much everybody. This first law, the Immigration Reform and Control Act, IRCA, affects everyone. So if you only have 3 employees and they're all your relatives, it doesn't matter. You are required to follow this law. What this law says, is that you must have documentation that says that people are authorized to work in the United States. And it's very specific. You should have an I-9 form and be able to produce that. So you should keep these in separate files, not in your employment files, your personnel files, on every single person that gets a paycheck. So if you have relatives, if you're on the payroll, you should have a form, and you have the obligation to produce that to immigration officers at any time to prove that everyone you have here is authorized to work in the United States. So, a couple key things. There's heavy fines on these forms. You can be fined up to $2,200 a form, and each error could be between $110 and $220. So you want to pay particular attention. So we audit companies on I-9 forms, and this is what we find. We find that they don't fill them out completely. So, for instance, you can use a Social Security card and a driver's license as documentation, or a passport. So, for instance, I have a passport out of Miami Passport Office. It says issuing agency on the form. You've got to put Miami Passport Office. The immigration people do not like abbreviations. They don't like blanks on this form. You need to completely fill it out. So this is one of those things where you really need to pay attention. And you may think, okay, well, would they ever come and audit me? And maybe the chance is low. I don't know how many of you are construction companies, obviously blue collar, agriculture, restaurants. Those are on the target list for immigration, but anybody could be audited. If your competitor or your neighbor thinks you have illegal people working for you, they can come in and audit. They are obligated to do that if there's a report. So it's not something you want to mess with. So pay particular attention to making sure the forms are signed. You have to keep documentation, like copies of the documentation. No. Is there a best practice for that? Yes, there's 2 sides of the best practice. One is that you want to be careful with having copies. You are not required to have a copy unless you have to do E-Verify. And that's, the E-Verify is by state. It's not a federal law. So most states require E-Verify, and you're required to keep the documentation. If you're in a state like where I am in Florida, you are not required to E-Verify unless you're a federal contractor or it's by your contract. And in that case, we don't recommend you keep the documentation because it does show race and age and those kinds of things that could be held against you. So if you're in a state where it is required to E-Verify, then you definitely want to make copies of the documentation, and you want to keep these I-9 forms in a separate form because you don't want immigration people pawing through your employment or personnel files. All right, let's move on to the next law, and that is the Fair Credit Reporting Act. And this affects everybody. And you'd like, credit reporting? I thought that was when I bought a new car, right? Well, it is, but it also is for this. And what this law says is you must have permission to run background checks on people, essentially, and credit checks. Not just credit, but background checks as well. So what you want to do is have a separate form. It cannot be in your application. It cannot be embedded in other documentation. It has to be a separate form and that you give to applicants. It gives you permission to go and check their background. The other part of the law where there's been a lot of lawsuits is it says that if you make a decision based on that background check, even if it's partially made on it, you must send a letter along with a consumer booklet explaining what they need to do to fix it to the person, explaining that you made the decision partially based on their background check, and giving them 30 days to make any corrections to it, much like they would with credit. And then after that 30 days, you are required by law to send a second letter that says it's a final disposition letter. So there have been a lot of class action lawsuits lately around this law and people not sending the letters out like they're supposed to. So keep in mind on Fair Credit Reporting Act, you must have a disclosure up front, and then you must send a letter and give them 30 days. And then after that 30 days, you must send them a final disposition letter. Okay, this is the big boy, and this is the Fair Labor Standards Act. This is the one that's controversial. This is the one that's in the news all the time. This is the one where you see tons and tons of lawsuits. So it's a law that was written in 1938. So that gives you a little clue. And it's only been updated a few times. It's been in the news lately because of the proposed change, which it wasn't really proposed. It was basically implemented by the Obama administration. And it was supposed to be put into effect on December 1st of last year. But then there was a court injunction against it. And there's been a lot of playing around with all of that with the new administration, and so that change has been in limbo since essentially December. And we're not sure how that's all going to play out. But let's talk about what the law is today. And what that is, this law is, it says it dictates three things. It dictates overtime, who, how, and all those things, who you have to pay it to, how it's paid, and minimum wage, and it dictates about minimum wage, federal minimum wage, and then, of course, child labor laws. We're going to spend the most time talking about the overtime. So basically, all of your employees, there are two different categories. We have exempt from the Fair Labor Standards Act and non-exempt. And of course, the exempt area is where we see a lot of problems, right? So exempt, in order to be exempt, you have to pass three tests. You must pass the salary test, and we're going to talk about each of these. And that you have to pay people on a salary basis, so that's a salary basis test, and then the duties test. So what you actually do in your job. So I want to make a couple points here. It's not how you pay people that makes them exempt. So I've heard small business owners say, well, I pay people a salary. If I pay them a salary, I don't have to pay them overtime. Well, not necessarily. Do they meet these three tests? So you can pay a non-exempt employee, which is somebody that you have to pay overtime to and minimum wage. You can pay them in a salary basis, but if they go over 40 hours, you must pay them time and a half. So the real question is, who's exempt and who's non-exempt? So this first test is the salary test. In order to even be considered to be exempt, you must pay a minimum of $23,660 a year, or $455 a week. Now, you might ask yourself, well, why do, $455, if I do the math, that's $23,660. If you pay people, say, lump sums, or you have a highly compensated person that, say, makes $100,000 a year, you must still pay them the $455 per week in order to be exempt. So that's the salary test. And of course, that's what the big controversy was, and the injunction, because that number was moving from $23,660 to now I can't even remember, $46,476. And that was a big jump, and everybody's complaining, and et cetera, et cetera. And we won't get into all that controversy. But the number you need to be concerned about today is the $23,660. Now, the second test is you must pay them on a salary basis. So what does that mean? That means that they're paid their salary whether they work 20 hours a week or they work 80 hours a week, right? The whole idea behind this is they're a salaried person, and you don't have to pay them overtime when they work over, but if they work under those 40 hours, they also don't get docked. And that's a very important factor. So when can you dock an exempt employee? You can take full day, and that's the key term there, full day dock. So let's say they've used all their PTO and they miss a whole day. You are allowed to dock them a whole day. However, you cannot dock them hours. So for instance, you have an employee, and let's say the school calls and their kid's sick, and they come to work and they work 1 hour in the day. They come in at 8, they leave at 9 to take care of their sick child. You cannot dock them PTO for that time, because that would be treating them like a non-exempt employee. So if they work any time, you must pay them. So that's very important, that salary basis test. So now they have a salary. Yes.
Will has a question. Will, are you there?
Hello.
Will, can you hear us?
Yes, I can hear you.
Okay, great. We can hear you as well.
Oh, great. There's quite a bit of confusion per my accountant's advice. I own a technology retail store. Basically, we service and sell Apple computers. And per the counsel of my relatively new accountant, that cannot put who I consider to be a service manager / store manager. He has to be paid hourly, and therefore overtime as well. And so I took his advice and basically added an employee interim, and here we are. Overtime is killing the business, and we're headed towards a small loss this year because of overtime and a few expenses, but basically extra employee and a lot of extra overtime. And his reasoning was, well, because we retail, if manager is only doing managerial duties, then he can be on salary. But since he's not only doing managerial duties, he's also doing some repairs and other retail functions, I have to keep him hourly. So can you offer any guidance on that?
Okay, and that is what thank you for the segue to duties test. And what state are you in?
New York, good old New York.
Okay, New York. So you have a whole set of fun state laws too.
Yeah.
So let's talk about the duties test. So we've talked about salary basis. Those are pretty simple, right? Don't dock pay, other than full day, and you got to pay them at least $23,660.
Mhm.
The duties test is where all and where your accountant is talking here. And this is all around job design. Okay, so there's 6 or 7, depending on how you count them, categories of duties. One is executive. Now remember, this is 1938, so think of executive, but this is your supervisory type exemption category, duties test exemption category. What this says, and your service manager would fall under this, is that in order to be exempt, they have to manage part of the enterprise. They have to supervise 2 or more people, and they have to, the third piece is the critical one, they have to have hiring or firing authority. So now the service manager can come to you or HR or wherever to get advice about that, but they have to really have a strong, influence when it comes to that hiring or firing authority. And then 2 or more. So if you're a very small business, you have a manager and they only have 1 direct report, they will not qualify under the executive exemption. Now, what your CPA is talking about is there's been a slew of lawsuits, and let's just use Jimmy John's Sandwich Shop as an example, where assistant managers at Jimmy John's were exempt and they were not being paid overtime. But we all know what Jimmy John's assistant managers do. They make sandwiches, right? Plus, they probably yell at somebody, hurry up, cut the lettuce, or why aren't you at work, or whatever, and they do some shift management. But a lot of their work is done, making sandwiches. And what your CPA is talking about, and it's a lesson for all of us, is if your service manager is also acting like an employee, doing work, repairing computers, and doing the work of non-exempt employees, the real question comes down to how much time do they spend doing that, right? And the law is not clear on this. There's no hard and fast 51%. Here's the risk continuum. What percentage of time do they spend managing versus doing kind of that hourly or non-exempt work? And on your risk continuum, you're more likely to get a lawsuit if they spend the majority of their time making sandwiches or fixing computers versus, doing management duties. And so that's true for everyone. It's not a black and white thing. So you've got to be very careful, and you need to have a job description that says accurately what the people do, and you really need to look at what percentage of time they spend management skills versus, and then you as the owner can take a risk. So if you're not making any money and you're going to go out of business, you could take a risk. But one of the things you want to do is look at job design and make sure that, that your people are really doing exempt work. So that's number 1 is executive. The second, number 2 group where you can exempt someone is administrative. And administrative doesn't require you to supervise people, but this is a squishy. I call this the squishy bucket, because the squishy bucket says that you have to manage part of the enterprise, and it needs to be a matter of significance. So what in the world does that mean, right? So people use this to exempt their administrative assistants. But if they're just managing your calendar, not helping you manage the enterprise, that's pretty iffy. That's in the kind of the gray bucket. If you have a purchasing manager that's buying millions of dollars of parts, that's a matter of significance. So you've got to be careful with the administrative exemption. And then we have professional, and there's 2 buckets for professional. There's learned professionals and there's creatives. So in learned professionals, this would be people with advanced degrees. But the key point here is that advanced degree has to be required for the duties of the job. So just because an individual has an advanced degree doesn't make the position exempt. It has to go with the position duties. And that's why that job description is so important. So scientist is originally intended for scientists and people that need advanced knowledge in order to do the work. Creative professionals, this is like a really big bucket that has artists and the violinists for the symphony and people that are in radio and TV, and they can be exempt as long as like original. So if you have graphic designers that work for you, unless they're creating their own work and they're not just modifying stuff other people created, that can be gray. So you have to be careful of that. Salespeople have their own kind of category. They do not have to meet the salary test, but they must be outside sales. So if you have inside sales, like in an Apple store, for example, that would not qualify. So inside salespeople are always non-exempt. Outside salespeople, they have to, the majority of time spent outside getting your old traditional salesperson, basically. There is no salary minimum. You don't have to pay them zip, right? But it has to be that duties test is outside. Computer also has its own salary amount, and that's $27.63 an hour. Now, computer, in order to be exempt on the computer exemption, they must be a programmer or a systems designer or systems analyst or a tester. It's that, I'm going to call it nerdy IT stuff. It's not being like a hardware person or a software person, and it's not the person you call when something's screwed up on your computer and they fix your screen or whatever. So it has to be the programmers and those higher level computer skills. And then I did mention before, there's also a highly compensated exemption bucket for people that you pay $100K or more. But like I said, they also must meet the minimum salary of $455. And they must qualify under one of these other buckets but the test is not as strict. This is a tough area, and the reason that Will's CPA is so excited about it is if you have to go back, you can sometimes have to go back normally 2 years, but they can go back 3 years on back pay, and there's fines and all kinds of things if you're found to be doing this wrong. So you want to get professional help to look at your jobs and to make sure that they're in the right buckets on this. We actually have a 2-hour class on wage and hour. I don't have a lot of time. I'm going to jump a little bit into overtime, but I don't want to take the whole class on this, but I'm happy to send invites if you guys send me your email information for our 2-hour class on wage and hour law. And so there is an amendment to this was passed called the Portal to Portal Act, and it dictates when and how you have to pay overtime. So the overtime laws, if let's say you are in manufacturing, your line breaks down, do you have to pay people while they're standing there waiting for the equipment? And the answer is yes. Same thing would be here in Florida, like we didn't have any power, so people couldn't use their computers, or the AT&T went down, or whatever that is. You must pay them for that time. So waiting for work, you must pay. Now, if power's not going to come back on, or the equipment's broken, you can send them home and you do not have any obligation to pay them. This is federal law, right? So each of you have state laws too that dictate, but we're not going to talk about that. So those are things that you have to be aware of. Common, errors with all of this is you can tell people no overtime. If they work it, you must pay them. So what do we do if they work and we didn't authorize it? Well, then you can discipline them or you can fire them, but you still have to pay them. Make sure that when you're signing off on timesheets, that you have timesheets, that you have a time record. And one of the things you definitely want to have is time records that are I don't know what happened here. Time records that are specific, like an in and an out. So you can just have a piece of paper. You don't have to buy a time clock or whatever, unless you're really large, right? So you can have a time record, but make sure it's in and out, like what time they came in, what time they went to lunch. If you make any changes to their time record, make sure you get initials. Okay, we have a question.
Yep,
you only need to hit one of the 3 exemptions. So we have an hourly employee who makes over $24K, but is not one of the exemption. It's a welder and a machinist, and we pay overtime. So you have to hit all 3. And let me say something about blue collar. All blue collar jobs are always non-exempt. So you may have an electrician that works for you or a plumber, and they make 60, 70, 90K. It doesn't matter. They're always non-exempt. Same thing with first responders, always non-exempt. Interestingly enough, there are 3 categories that are always exempt: doctors, lawyers, and teachers, believe it or not, which doesn't seem quite fair. But those are always exempt. So there's a lot of nuances. If you're in agriculture, you probably want to email me. And there are some carve-outs to the FLSA. No doubt, some kind of deal that was made in Congress back in 1938. But it's a pretty short list in terms of carve-outs. So you want to be very educated on this. This is a huge liability for your company. It's a big money maker for labor law attorneys, and this is low-hanging fruit for the government. Okay, let's move on because I want to get to some of these other laws. But this is a really important one, and one that you want to make sure not only you know about, but also supervisors and managers that work for you. So they're not making mistakes, and you want to make sure you know what they're doing. They're not telling people to work off the clock. You know, that is an accident waiting to happen for you, and it's going to cost you a big check because someone will report it. One of my employees, you know, we're an HR consulting company here in Florida. One of my employees, our accounting person, came and asked me one day. She said her son was going to work at a taco restaurant, and they were making him come in on Saturday mornings for a meeting. It was lasting 2 hours, and they weren't paying him for the meeting. Well, you have to pay employees for meeting. You have to pay them for training. There are some exceptions, but it's a short list. And coming in for a staff meeting on a Saturday is definitely something that you have to pay for. Okay, moving right along, I mentioned the equal pay case when I first started. Basically, you got to pay men and women the same. Now, here's the thing. It has to be equal, right? So it's equal conditions, equal experience, equal seniority, equal performance levels. All other things being equal, you must pay them equally. So that's the Equal Pay Act, and that applies to everybody. This is also a law, USERRA, Uniform Services Employment and Reemployment Rights Act, that applies to everybody. So you may only have 5 employees. This applies to you. What this law says is you can't discriminate against the military. You can't discriminate when you hire them, when they tell you that they're going to go out on deployment. And you actually have to guarantee their position, and I'll talk about what that guarantee means, for up to 5 years. So say you have somebody, you hired them, they come in, they say, hey, I have to go on deployment, I'm going to be gone, I don't know how long. So they go out. They call you 4 years later and say, hey, I'm back and I want my job back. And you say, hey, well, that's great, but I don't have a job. That would be the wrong thing to say. You have to either create a job or get rid of somebody else. Up to that 5 years, their position is guaranteed. And it doesn't have to be the same job, but it has to be equal from the perspective of pay and benefits and seniority and those kinds of things. This is a hard thing for small employers because you don't have a lot of jobs, and it's hard to create jobs, but this is the support of our military. So that's USERRA, and it applies to all employers. Okay, so then we have laws that apply to based on the number of employees, and some of these are like workers' comp is state dependent. So generally it's right around 4 or more full-time or part-time employees where it kicks in, and in some states it's everybody has to have it, and it might be, the number might be 2 or whatever. It just depends on that state. So you want to check on that. But I want to also talk to you a little bit about why it's a good idea to have workers' comp. So what does workers' comp do for us? Well, what workers' comp does is it protects us as the employer. So the minute someone goes on workers' comp, we're not paying, right? The workers' comp company is investigating, they're managing it, and they're paying the person. And if you don't have workers' comp, then you have liability. Somebody goes out, and let's just take you have an intern for the summer, and they're a young person, and they're texting when they're driving. Can you imagine that? I can hear y'all chuckling because you see it every day. At least we do down here. And You send them, hey, run up to the Jimmy John's and get some sandwiches for lunch. And you send them up there, they get in a wreck, they're killed or maimed or something happens, and they're not covered under workers' comp. Their parents are going to sue you. You're going to get sued. Under workers' comp, you're protected. So that's really critical. And speaking of interns, the day of free interns is over. You want them covered by your workers' comp. You want to pay a minimum wage so that they are an employee and you have insurance to cover you on that. And case after case, it's very rare that you can actually have an intern that you don't pay. I mean, they'd have to come from a school. The school has to, then you would want to make sure the school is covering them from an insurance perspective and that they don't do work. So this is a big area of controversy and an area where you need to be careful because if you have any summer help or interns or those type of jobs, to make sure that you're covering yourself. Number one workers' comp is auto accidents. And it's as simple as sending somebody to Staples or to the sandwich shop. Now, state laws. And Will mentioned he was from New York. I don't know where everybody else is from. State laws you've got to keep up on. You know, basically whatever is the best deal for the employee is. So state laws, for instance, we didn't talk about child labor, but in child labor cases, there's the federal child labor laws. Almost every state, the child labor laws are more restrictive than the federal. So those are the ones that would take precedent. So if you're in New York, you've got all kinds of different laws around final pay, and New York, New Jersey have laws around breaks. So you really have to be up to speed. And I don't have it on the slideshow, but you also have municipalities. So you have municipalities that you know might have laws about sick leave. They have laws about minimum wage. They typically have human rights ordinances in terms of expanding laws in terms of the LGBTQ community, those kinds of things. And you've got to be aware of those and make sure you know whether they apply to you or not, and making sure you're not only complying with those, but also complying with the notification requirements, communication, things like your handbook, etc. Now, speaking of those kinds of laws, let's talk for a minute about the Title VII of the Civil Rights Act. It's passed in 1964, part of that, all that big social legislation. For whatever reason, and I'm saying some kind of small business lobbying group or whatever that came in, this does not kick in until you have 15 or more employees. So what does that mean? Well, does that mean, well, if I have under 15, I can discriminate? Well, you could, but you probably go out of business for PR reasons, right? All this means is they cannot sue you under that Civil Rights Act in federal court. What does the Civil Rights Act of 1964 say? It says the big five: race, color, national origin, religion, and sex. Now, I want to talk about sex. Not that kind of sex, guys. Okay. No, we're talking about sex discrimination. What does that mean? Well, that means that's gender. What the word we use in these days are gender, like males and females. You can't discriminate based on somebody's gender. You cannot, you have to, the sexual harassment law falls under the sex discrimination part of the Civil Rights Act. So you have to have a workplace free from sexual harassment. Two kinds of sexual harassment: quid pro quo, like if you sleep with me, I'll promote you, something for something. And then the more pervasive one these days is hostile work environment sexual harassment. And that's the tough one, because hostile work environment is, you know, up to interpretation, correct? We have a lot of millennials and young people in our workplace, and they see a lot of hostility in the workplace, and they will not tolerate that. Having said that too, that no matter what happens with this kind of legislation, or if it doesn't apply to you, we know younger workers don't see color, they don't see sexual orientation, and they do not understand organizations that discriminate against people based on those traits or labels. So it's to your best interest in all respects. We're becoming a more diverse society, and that means your customer base is more diverse, to make sure you comply. Sexual harassment is a huge issue these days, and you need to make sure that you have a strong policy, that you're training your managers on what to do if someone complains, that you know what to do if someone complains, and that you take it seriously and deal with it properly. Okay, moving on to more fun subjects. Age discrimination. So age discrimination kicks in at 20 employees. It's interesting in Florida, talking about a state, the state law is at any age. The federal law, I guess, thinks that at 40, then you're over the hill. And, you know, people might start discriminating against you when you're 40. I thought it was just when you got gray hair, but federal law says 40 and up. So what does that mean for you? Say you have a very physical job. You've got some 80-year-old that comes in and applies. Do you have to hire them? Well, that depends, right? The real question is, do you have a good job description that lists the physical requirements of the job? So maybe you have a physical job and it says you have to lift 40 pounds. Well, first thing is, do you really have to lift 40 pounds? Go weigh your stuff. Does it really weigh 40? And then if the person that applies, it's not about their age, right? It's about whether they can meet the qualifications. Do they have the qualifications to do the job? And one of those qualifications is the physical requirement. So that's why those job descriptions, that's why HR people are always harping on those things. And I hate them too. I hate writing them. But that will help you with these kinds of issues. You know, there's case after case of, I want younger employees, and owners actually saying that, or that we're a young outfit and we want to reflect that. You don't ever want to say that out loud, because somebody will record it, and then it'll come back to bite you. So you want to treat everybody equally, regardless of any of these things. You know, regardless of the Title VII things, right? And regardless of age or disability, which we're moving on to next. But that doesn't mean you have to hire people that aren't qualified, right? So you want to make sure that you really have your act together in terms of what those qualifications are for the jobs, and what you know, what you need. And you've got to make sure it's justifiable, because that is your obligation as an employer. Let's talk about ADA, American Disabilities Act. So this is a tough one. This is 15 or more employees. And basically it says you can't discriminate based on physical or mental disabilities. And the law also says you must provide reasonable accommodation. Now, obviously, reasonable accommodation for your small business isn't the same as reasonable accommodations for, say, Bank of America. But reasonable is reasonable. And what does that mean? Well, think of a jury. Think of maybe your mother on the jury or your grandmother on the jury. Would they think it's reasonable or not? So if you had somebody, let's say, that applied as receptionist for your position, and you have a high, you know, I call it a high boy, but a high receptionist desk, and it would cost you a couple $100 to lower that desk so somebody in a wheelchair could do that job. Is that reasonable? Well, yes. Would it be reasonable if you had to modify a piece of equipment and pay $100,000? Probably not. Here's the key thing. You should have ADA compliant job descriptions. And to be ADA compliant, it has the essential functions of those jobs, and also lists what the physical requirements. And you want to make sure that's accurate, whether they have to be able to walk or kneel or finger, because there's soldiers coming back without hands. Can somebody without a hand do the job with reasonable accommodation, right? Now, mental disability is a whole nother story. And that can be a really tough area where you want to get some professional help if you either have an employee that is starting to exhibit mental issues, or hiring someone that may have mental issues. Now, this also covers things like autism and other kinds of disabilities. And of course, I would highly encourage you to try to employ people that do have disabilities, because it's good for our country as well. So if you can create jobs that disabled people can do, they will be very loyal employees. I actually have an autistic son and who's 24. I've had a really hard time finding him a job. He's a great worker. Never sick, never calls in sick, doesn't really talk, so there's not a whole lot of drama. He just works. And yet I've had a hard time finding him a job. So I would encourage you to, be familiar with the ADA and see if there's ways that you can help people that need jobs, that want to work. And when it comes to your own employees and issues around ADA, it can be very volatile, and you need to make sure that you're aware of the law and what you have to do. Let's talk about FMLA. Now, many of you probably don't have 50 or more employees. So I'm not going to go into a lot of detail on FMLA. If you have 50 or more employees in a 75-mile radius, then you are subject to it. And that what it says is you have to provide 12 weeks of unpaid leave while maintaining benefits and job guarantees. And it's a complex law, just like ADA. But as a small business owner, we're going to have people have babies. We're going to have heart attacks. We're going to have people have to have operations. So you have to think through your leave policy. What am I going to do? Am I going to keep jobs open for people? Are we going to fill in with temps? Are we going to, have other people fill their slot while they're gone out for their surgery or whatever that is? So you need, just because you're not subject to FMLA, that doesn't mean you don't need a leave policy. And I encourage you, this kind of happened to me, and I'm an HR person, so I left corporate and I started my company, and I think I had 5 or 6 employees, and one of my employees had to go out for surgery for 6 weeks, and I hadn't thought about it. Of course, they want to know, do I get paid? Do I not get paid? Are you going to hold my job open? And it kind of caught me off guard, the employee asking me, because at that time I had a business partner and I hadn't discussed it with her, and, it was hard. So all these things, and of course that speaks for having a good policy guide where you thought that through ahead of time as well. That's the big advantage of a handbook, is it's a good communication device for employees, but it's more you deciding what your policies are, which is critical and helps you to be consistent. All right, so let's look at some other laws that apply to everybody, and that's negligent hiring. So I use the cable rapist guy as an example. So you hire somebody, but you don't do a background check, right? Maybe you don't do a background check, or you don't check references. And I recommend you check 3 references on every single hire and document it. Even if you can't get a hold of people, at least document that you tried, okay? But 3 would be great. And do background checks. And I know they're expensive, but, negligent hiring says you didn't do what you were supposed to do as an employer, and you should have. And now you sent this guy out to my house and something bad happened. That's negligent hiring. Negligent supervision is you have people working for you and you're not supervising them properly, and they did something to hurt somebody or do damage to my house or whatever that might be. That's considered negligent supervision. So you got to get out of your office or get in your truck or whatever business you have, go to the store, walk around. You got to be aware of what's going on. A lot of these cases I mentioned this morning, where in the heck is management when these things are going on? When the guy's taking the tractor driver off and propositioning her, the KFC person. What is going on there? Not good supervision. So you've got to be supervising. Now, negligent retention, I can really get this one. This is like if you're a nice guy. I'm kind of a nice guy, and give them a second chance. Something bad happens. Let's say somebody is, screaming or potentially, kind of heading towards violence, and you counsel them and you give them a second chance, and then something bad happens. Somebody gets hurt. That's negligent retention, where you should have gotten rid of them. So be careful of that, because if you're nice and you want to give people second chances, this can come back to bite you in terms of negligent retention. Because if you knew they had violent tendencies, or you knew that they potentially could hurt somebody, and you didn't go far enough and you didn't deal with it, you can be held liable for that. I have invasion of privacy up here because That is a huge issue these days. What's private and what isn't. And we have a whole 2-hour class on social media, so I don't want to really go into that. But be aware that, this is being tested in the courts, and you may not be able to tell your employees what they can and cannot say or do on their own private time. So you want to be aware of that, and a red flag should go off in your head that maybe I better not discipline somebody or fire somebody for something they said or did before I check with someone. All companies are, and I don't have a slide on this, subject to the National Labor Relations Act, which gives employees the protection on concerted activity to band together on things that are work site related. So that would be an example of if they think that the equipment is going to hurt somebody, or if there's a safety issue, or they're being unfairly treated from the perspective of work site conditions. So you have to be careful if they're complaining about that on social media on their own time, or getting together in a bar after work to complain about you or whatever. You want to have a red flag and make sure you talk to an expert about how to handle those situations. And I mentioned payroll taxes because I hear all the time about people not paying them. And of course, if you want an orange jumpsuit, that's a good way. Don't go down that path. So make sure you pay your payroll taxes. So I have one other huge issue that I want to talk about today, and then we can kind of open it up, for questions. And that is, what I've been talking about is counting employees. But one of the things that a lot of small business owners have are independent contractors. Now, everybody wants your independent contractors to be employees. Well, who am I talking about? Think about it. There's no workers' comp premium. There's no unemployment premium. There's no payroll taxes. So everybody is not getting their share of your money when it's an independent contractor. So you want to be very careful. So IRS has a 20-point test. It's on their website. You can look it up, or if you email me, I can send it to you. And that says, are they really independent? I like to use the plumber test. Okay, plumber comes to your house. You've got, say your toilet's blowing up and you got the water works. You call them. They don't come out when you want them to. They come out when they can, right? When they want to. So having control, if the independent contractor has control over their scheduling, that's one of the tests. So the plumber comes, he's got a truck, he's got his own equipment. You're not providing equipment. He knows how to use the equipment. You're not providing training. He has his own training. He comes and fixes your toilet, but then he does something wrong. And he makes a mess in your bathroom. He has to clean that up at his own expense. He has an opportunity for profit or loss. He has his own marketing materials, has his own insurance. All those things are part of the test. So if you're using independent contractors as an alternative to an employee status, because maybe the independent contractor would rather be paid that way, that's not the test. The test is this 20 points. And if you do this wrong, once again, they can go back and get back workers' comp. When you do a workers' comp audit, let me see your independent contractor files. You should have a contract with that person because they're their own business, just like you're your own business, right? Where are all these things? And then they can go back and collect back premium or back wages or whatever that is. So this is a really critical piece and another area of vulnerability for you as an employer. So how can you comply? The rule of thumb has always been, you have a professional HR person at 100 employees. Well, most of us in the Emerging Leader Program don't have 100 employees. So what do? You got to use experts, consultants, helplines, lawyers. And one of the things that's really critical is this stuff is moving so fast, whether it's state law, federal law, court cases, what the new administration is changing or not changing. And it's hard to keep up, and you don't want to act on things that you just see in the news. You want to make sure you have experts. So get an expert to help you, whether that be a consultant or a lawyer or a helpline, and make sure that you're doing this right, because it can mean all the difference in the world to your business. And there's lots of best practices, which I wish I had time to go over, but that's we're just about finished, and I want to be conscious of your time. So if there are questions, I'll just throw that open to the group. And you can type them on here, or you can ask, right, Jessica? Not Jessica.
Yes, Alicia, you can ask.
Alicia. You know, one common question that we get asked on our, we actually have an HR helpline, is about breaks. And I want to talk about this. This is a wage and hour issue again. By federal law, you're not required to provide anybody a break or a lunch. Now, when I know somebody's on here from New York, and New York obviously has a break law, and in your state may have a break law. The rule, though, is that you must pay for any break that's 20 minutes or less. So if somebody takes a 10-minute break in the morning and 10 in the afternoon, you must pay them for that time. Lunch is a little bit different. Lunch is 30 minutes or less than 30 minutes, you must pay for that time. But if they take 30 minutes or more, you do not have to pay them. So you want to be conscious of that. Employees are so smart. They have smartphones. They can look this stuff up, and you'll see them taking 29-minute lunches because they know they're going to get paid for that time because they know the laws that well. So that's a really critical piece. And then be conscious of whether your state has additional requirements when it comes to breaks. But that is an issue. Another issue is smokers. So what do I do about smokers that take 5 breaks? Well, by law, under the Fair Labor Standards Act, you've got to pay them for those breaks unless they're over 30 minutes. How do you manage smoke breaks? You could set a break schedule and say you have one 15-minute break in the morning and one 15-minute. Smokers are not protected, so you can tell them that. And then, you know, there may be some fallout with those that are, you know, 6-pack a day people. But that's something to think about. I mean, do you even have to hire smokers? There's no federal law that protects smokers, so you don't even have to hire them. Although last statistic I saw was about 30% of the working world smokes, so it's still a pretty high percentage. So you may be not attracting some pretty good people. So breaks can be a big issue, and of course the other thing on breaks is, should you offer them? Well, you know, it depends on your business too. You know, obviously if people working in the heat and or without in the cold. I forget about cold because I'm down here where it's hot all the time. But or then in the cold and they need a break from that, you certainly want to do that. It can be a recruitment issue. It can be a morale issue. It can be a productivity issue. So we have the law, but we also need to think about all those other aspects of really running a great business where people want to work, are going to say positive things about you. And it's interesting. Today I had 2 situations where I went to a restaurant chain and it was actually a sales call that I was calling on them about our services. And I had such a great feeling from the place. I mean, you walked in, everybody was friendly and nice, and can I help you? And let me show you where the office is. And all the people were so nice and warm. When I was driving there, I called up my doctor's office, and I got somebody that obviously was having a really bad day, was just really cranky on the phone. I'll transfer you, you know. And, you know, when you think about HR for our businesses, which do you want? Do you want that warm feeling where people want to be there and they feel good about, is management even aware at the doctor's office this person's obviously having a problem? Or is she cranky all the time? I don't know, you know, but it doesn't give me a warm and fuzzy feeling about going to the doctor there. And, you know, people will change they have other opportunities. They may change where they do business based on that. So all these things about how people feel and morale are really critical. The law is one thing, you know, you got to know this stuff. If you don't know, you know, you're going to get yourself into trouble and you got to keep up with it. But the other piece of HR, which is so critical, is the piece about, you know, forming your culture and having, and we talk about that in the HR module in Merging Leaders, and it's important. We do have one question here, and then we'll wrap up. do you have a suggestion on how to stay up to speed on state laws? I'm in Washington State. You know, it's really hard, and Washington has been prolific. I know, so we have a state update service that we provide our clients, and I know this summer just one, I think it was June or July, I think it was things were effective July 1 in California, and we monitor, by the way, we monitor Washington and California, and they're very prolific states for state law changes, and municipalities there as well. But in California, just for our July 1 update, there were 20 different changes. So, I mean, it's hard. And if you're in one of those, I call them the coasts, not the Midwest, not the South, but, you know, either the West Coast or the East Coast, it's hard to keep up. So you want to subscribe to a service, you know, like what we provide that monitors it for you. Because I have a full-time person, that's all they do is monitor the state, federal, and court cases. And I mean, I couldn't keep up with it myself. So, I mean, it's just, it's crazy. It really is. I really enjoyed this time, and I want to thank you for joining us today. You got my email if you have any other questions. You also have my phone number. I'm here in Florida, so I'm on Eastern time, but I'm happy to help you in any way. And if I can answer a question that you didn't get addressed or would like to ask in private instead of in front of everybody, I'm happy to do that for you. Committed to the Emerging Leader Program, and I want your business to grow. And I think HR is maybe the most critical piece of that. So I've enjoyed our time together, and go out there and make some money.
Okay, thank you so much, Suzi. Thank you, everyone, for joining. Got some great comments. Everyone saying thank you. This will be posted later on this week. The link as well as the slides. So thank you, everyone. Have a great day.
Bye.